Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in today's video I'm going to talk about one of the most misunderstood legal principles, theories, laws, whatever you want to call it, when it comes to debt collection lawsuits, and that is the statute of limitations. We're going to talk about what it is, how you calculate it, and whether it's a defense you can actually use to get rid of your debt collection lawsuit completely. If this is your first time here to my YouTube channel, please go ahead and click subscribe. Check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt issues. All right, let's talk about the statute of limitations. When it comes to debt collection lawsuits, here in my law practice in Arizona, that's one of the number one things people ask me about is they say, you know, this is just so old. They shouldn't be able to sue me anymore. Hasn't the statute of limitations expired? So it's a great question, and it's a strong defense, powerful defense. It's one of those defenses, if they have filed a lawsuit against you and the statute of limitations has expired, you're going to win. 100%, you're going to win. You're going to get this thing thrown out. So it's important to understand it. Now, the statute of limitations deals with the amount of time a creditor has to file a lawsuit against you after the account has gone into default. Now, one thing that a lot of people kind of get confused is if a lawsuit has been filed and a judgment entered against you, and then that judgment is out there, it's different than that. We're going to talk about that at the end of the video. So hang around to, if a judgment's already been entered in your case, wait till the end. I'm going to talk about that specifically. But if you have a credit card that's gone into default, and now the creditor has filed a debt collection lawsuit against you, how you can calculate the statute of limitations is this. First, you need to look at when the account first went into default. Now, if you talk to the creditor about this, they're going to have a different opinion as far as when the clock starts ticking on this statute of limitations. They usually say that when the account is charged off is when the statute of limitation clock starts ticking. There's a problem with that. That's not what the terms and conditions say in almost every credit card agreement out there. See, charge-off typically happens 6 months after you stop making payments on the card. However, if you look at the terms and conditions on the credit card agreement, it's going to state that you are in default on that as soon as you miss one payment. So as soon as the account goes 30, 60 days past due, that's really when the statute of limitations starts running. Now, the second thing you need to know is how long is it? What's the applicable statute of limitations? Now, this varies from state to state, and it even varies from different types of debts. We're going to talk about that as well. So you need to find out what the statute of limitations is for a contract in writing. Some states, like Arizona, where I practice law, actually have a statute of limitation that is specific to credit card debt. So you need to find out what it is. For our example here today, I'm going to use the Arizona statute of limitations as it relates to credit cards and written contracts, and that is 6 years. There's a 6-year statute of limitations in Arizona when it relates to credit card debt. So the first thing we do, like I said, is we look to see is when did that 6-year period start running. It starts approximately 30 days after you miss your first payment. Then you have to go and look at when did they file the debt collection lawsuit. If they filed the lawsuit, you go back 6 years from the date that they filed the lawsuit. And if it's been more than 6 years, then you know that it's outside the statute of limitations. However, if they haven't filed a lawsuit and it's been more than 6 years since you missed that last payment, then you know that they may not even bring a lawsuit because it is outside. The statute of limitations has expired. They can no longer sue you without running afoul of the statute of limitations law. So that's how you calculate it. It deals with the time period before the lawsuit is filed. If a lawsuit has been filed, the easiest way to do it again, go look at the date it was filed with the court, go back, in Arizona, you'd go back 6 years, and if your last payment was made more than 6 years before that lawsuit was filed, that's how you know it's outside the statute of limitations. On the other hand, if it's been a shorter period of time, if you missed the payment and then it's been 3 years, and then they filed their lawsuit, they're within the statute of limitations, and you're not going to have that as a defense. Now, if they have filed a lawsuit and they are outside the statute of limitations, then what? Then you can file a motion to dismiss. The motion to dismiss needs to state that this is outside the statute of limitations. You'll have to reference approximately when the last payment was made. Sometimes you can look at your credit report to get that information and be able to provide that to the court. That, look, this is when we made the last payment. This is when it went into default. It's now beyond the time period that the law allows in your particular state. and the court should grant that as long as you can show as far as when the last payment was approximately made. So that is as it relates to credit cards. Now, different types of debts do have different statute of limitations. For example, oral contracts in the state of Arizona have a statute of limitation period of 3 years. And so it's a different time period. However, one of the big things that we see in the debt collection world are installment loans. So credit cards are a revolving account. Written contracts, they're a little bit different. But when it comes to installment loans where you have a set payment each month for a certain period of time. You can think of car loans, you can think of student loans, those types of things. Some personal loans like a signature loan from a bank. It'll have a loan for 8 years and it's going to be $250 a month or whatever it is, and it's going to have a set amount. Now in the state of Arizona, there's case law that says that each of those individual monthly installment payments carries its own statute of limitations. Let me explain what that means. What it means is if a lawsuit has been filed, you can look back, again in Arizona, you would look back 6 years because that is the amount of time for a written contract. And any individual installment payment that is beyond that 6-year period is barred by the statute of limitations. So it may be something with an installment loan where a portion of the monthly payments are within the statute of limitations and therefore they can try to be collected on or they can file a lawsuit, whereas a portion of them may be outside the statute of limitations and therefore they'll be barred by the statute. So that may be a good way to get a case either partially dealt with or even a good settlement, because you can reach out to the creditor and say, hey, look, a portion of these installment loans are outside the statute of limitations. So that's how you deal with that before a lawsuit is filed or when a lawsuit is filed in determining if the creditor still has a valid claim. Now, what if a judgment's already been entered? This is the example I get often here in my law practice in Arizona. If someone comes in with an old default judgment or something along those lines, or the court process has already played out and there's a judgment that they're dealing with. And they may say, look, John, this thing was entered back in 2005. It's got to be outside the statute of limitations. Now, in every state, there is a period of time as far as how long a judgment is valid or good or collectible for. However, in most jurisdictions, those judgments can be renewed. For example, in Arizona, once a judgment is entered, it's good for 10 years. And at the end of that 10 years, the creditor has the option of renewing it for another 10 years for the rest of your life. And so statute of limitations is a little bit different. The way to think about it is statute of limitations arguments are before the lawsuit is filed or right when it is filed. Once a judgment has been entered, then you're dealing with your state's particular statute as far as how long a civil judgment is valid. And again, like a state in Arizona, it's 10 years and can be renewed every 10 years. And that's why I always say it's important to deal with judgments. I mean, you want to avoid it altogether, but if there's a default judgment you didn't know about, there may be some different options to maybe have it set aside, to settle it, or look at a bankruptcy option, because they typically do not just go away. And not only that, interest continues to accrue on those things, and it could turn a $5,000 judgment into a $30,000 judgment over the years. So it's something that's got to be dealt with and hopefully resolved once and for all. So I hope that helps you when it comes to the statute of limitations. If you have a lawsuit or a judgment that you need some help with and you're in the state of Arizona, my information's below. Feel free to reach out to me to set up a consultation. You'll talk to me personally, and I can walk you through what some of your options are. Thanks for watching today.